Hello, good afternoon. I'm April Farris, and I'm the president of the Houston Lawyers chapter of the Federalist Society. I'd like to welcome you all to our Zoom dialogue on the future of originalism. I'd like to thank the Austin Lawyers chapter for co-hosting with us, and also special thanks to Judge Oldham for moderating our discussion. Before we begin our discussion, I'll begin with a few brief instructions. The audience will be muted for today's event, but beginning at 12:45 p.m., we will open the floor for question and answer. If you're dialing in today, you can ask a question by pressing *9 on your phone. If you're joining us by Zoom, you can click on the hand icon to raise your hand and ask a question. Also, you can submit a written question using the chat function, and that function will be open later during today's program. With that, I'll turn to our presentation. Our moderator today is Judge Andrew Oldham. Judge Oldham was confirmed to the Fifth Circuit in 2018. Before ascending to the bench, Judge Oldham served as general counsel to Texas Governor Greg Abbott, where he advised the governor on a range of issues under federal and state law. He also managed litigation in which the governor was an interested party. Before that, he served as Deputy Solicitor General for the state of Texas, where he represented Texas in federal courts across the country, including twice before the United States Supreme Court. Before entering private practice, Judge Oldham served as a law clerk to Justice Samuel Alito at the U.S. Supreme Court of the United States and to Judge David Santel of the U.S. Court of Appeals for the D.C. Circuit. He also worked as an attorney advisor in the Office of Legal Counsel at the U.S. Department of Justice from 2006 to 2008. Judge Oldham earned his bachelor's degree from the University of Virginia with highest honors. He then attended Cambridge University, where he earned his master's in philosophy, and he also graduated magna cum laude from Harvard Law School. Welcome, Judge Oldham.
Thank you very much, April, and to the Houston chapter and also to the Austin chapter of the Federalist Society. It's a great privilege, a great honor to be here to talk about a very exciting topic and one I know has been hotly debated and hotly written about in lots of different corners. And I hope that today's dialogue will provide a useful contribution to that conversation. We have three amazing panelists, another credit to the Federalist Society in organizing this event. Our first speaker today is Ilan Wurman, who is a visiting assistant professor and incoming associate professor at the Sandra Day O'Connor College of Law, where he teaches administrative law and constitutional law. He writes on administrative law, separation of powers, and constitutionalism, and his academic writing has appeared or is forthcoming in the Yale Law Journal, the Stanford Law Review, the University of Chicago Law Review, the University of Pennsylvania Law Review, the Duke Law Journal, and the Texas Law Review, among other journals. He's also the author of the book A Debt Against the Living, an Introduction to Originalism by Cambridge University Press in 2017, and the forthcoming book, The Second Founding, an Introduction to the 14th Amendment, also by Cambridge, forthcoming. Ilan was a law clerk to my wonderful and esteemed colleague, Judge Jerry Smith, in 2013 and 2014. Our second speaker today will be Josh Hammer. He is an opinion editor of Newsweek, a syndicated columnist of Counsel at First Liberty Institute, a Blaze TV contributor, and a campus speaker through Young America's Foundation and the Federalist Society. Josh previously worked at Kirkland & Ellis, LLP, and he clerked for another of my wonderful and esteemed colleagues, Judge James C. Ho, on the Fifth Circuit. Josh has also served as a John Marshall Fellow with the Claremont Institute and as a law clerk for Senator Mike Lee of Utah. His first piece of legal scholarship on the topic of judicial supremacy was published in 2020 by the University of St. Thomas Law Journal. He's also been published by many other leading lay outlets, including the Los Angeles Times, the New York Post, National Review, First Things, Fortune Magazine, Fox Business, the Jewish Telegraphic Agency, the Jewish Journal, and the American Mind. Josh graduated from Duke University, where he majored in economics, and the University of Chicago Law School. Last, but certainly not least, is Frank Buckley, who is a foundation professor at Scalia Law School. His most recent book is American Secession, The Looming Threat of a National Breakup, published this year in 2020. His next book, Curiosity, will be published by Encounter Books next year in 2021. So with that, we'll turn it over to our panelists. Our format for today, much like many of our in-person Federalist Society panels, is each presenter will speak for about 10 minutes. I'll give them a warning with about a minute to go. Then I'll ask a few questions of the panel to hopefully create a certain dialogue, and then we will open up to the audience. So without further ado, Professor Wurman.
Thanks so much. Thanks to everyone for hosting this event and including me in it. My 10 minutes of remarks will be loosely based on my book, A Debt Against the Living, Introduction to Originalism, which I was pleased to present to the Houston Federalist Society 2 or 3 years ago. But the thrust of my remarks today will be the connection of originalism to the common good. And I'd like to establish that connection in 2 steps. The first step is a bit easier than the second step. The first question is to ask, what is the role of legal texts in our legal system as a general matter, especially public legal texts like statutes, treaties, and constitutions? The answer, I submit, is that they are instructions, public instructions, either to us, to our legal officials, or both. As such, they're interpreted the same way any communication intended as a public instruction is interpreted, with its original public meaning. Put another way, statutes, treaties, and constitutions are not Socratic dialogues. We don't interpret them esoterically. They aren't poems or novels either. And they aren't secret instructions conveyed by military code talkers. They're public instructions. So we interpret them with their public meaning, just like you'd interpret a fried chicken recipe from 1789 with its public meaning, to borrow an analogy from Professor Gary Lawson. This also means that we interpret these instructions with their original meaning, because that's the meaning the authors intended to convey, right? And so only the original meaning conveys the actual instruction. Now, this point seems so obvious to me, but for some reason, maybe it's not too surprising. Some people, especially many academics, have a difficulty grasping this point. So I want to explain why the contemporary public meaning doesn't work as a method of interpretation. There are only, I think, 2 ways in which the contemporary meaning will diverge from the original meaning. Okay, the first way is linguistic or semantic drift. So today, to take a prominent example, domestic violence means spousal abuse, whereas in the Constitution, it refers to insurrection. Surely the domestic violence clause does not today authorize federal legislation against spousal abuse. And I'm putting aside the 14th Amendment for purposes of this discussion. The point is, it would be crazy to allow accidental drifts in language to determine the content of our laws. No political theory, that I know of anyway, would justify letting linguistic drift determine legal content. If it did, right, if accidental shifts in language determine the content of our law, then we would quite literally be living in a system of accident and force rather than reflection and choice. The only other way that original meaning might diverge from public meaning is if intervening actors have convinced us that the language should be interpreted differently. And so we, the people today, see the language through that intervention. Let me take the 6th Amendment as an example. To the modern ear, having the right to counsel sounds as though it means the government has to pay for your lawyer. But that only sounds right to us because for 60 years, we've been told by the Supreme Court that that's what it means. And so it sounds plausible. But of course, it's actually totally implausible. Apply that logic to the 1st or 2nd Amendments. Do you have a right to a government-supplied firearm? To a taxpayer-subsidized New York Times? Of course not. We only interpret the 6th Amendment differently. We only hear it differently because intervening political actors, judges, who are supposed to be controlled by the Constitution, decided at some point to change the law of the Constitution rather than be controlled by it. Okay, so that's the first thing I wanted to say. These are legal instructions and we interpret them with their original public meanings. But that leaves the much bigger second question, the second step of the analysis. Are we bound to the particular legal instructions in our legal system? In other words, yes, we may interpret statutes as a general matter with their original public meanings because they're instructions to us and our legal officials, but we only do that because we're bound to them, because we're bound to those statutes, right? only being bound explains why we follow even the bad statutes, right? Only being bound explains why we follow even the bad statutes that Congress enacts. So in our system, we recognize, in the case of statutes, that the democratic process through which statutes are enacted confers legitimacy on those laws such that they are binding, all of them, even those we don't like. In other words, whether statutes are binding is a question mostly separate from the question of what those statutes as instructions actually command or direct. Well, what about the Constitution? What makes a Constitution legitimate and therefore binding? It may not be the same thing that makes a statute binding, that makes ordinary law binding. Well, in my book, I argue that what makes a Constitution legitimate and therefore binding, even in the face of disagreement over its particulars, is a threshold success in balancing self-government on the one hand, allowing people to band together to legislate for the common good, and liberty on the other. These two objectives, however, are in tension. We all know it's often popular majorities that infringe on the rights of minorities. The framers were very cognizant of history which included numerous attempts at creating a common good that ultimately ended in tyranny. So they sought to frame a constitution that successfully balances not only self-government, but also liberty, a balance that is extraordinarily difficult to achieve. My claim is that the framers were remarkably successful for their time at creating a constitution that balanced these competing objectives through ingenious mechanisms: the separation of powers, checks and balances, the enumeration of power, the Bill of Rights, the representative mechanism itself, all were novelties. But more importantly than that, the framers, I submit, wrote the Constitution in such a way that it would continue to strike a successful balance between self-government and individual liberty long into the future on both sides of the equation. On the liberty side, the rights protecting provisions of the Constitution are written in sufficiently broad terms so that their fixed meanings can and do apply to new and changing circumstances. We all know this, hence the First Amendment applies to speech on the internet. The Fourth Amendment applies to GPS devices that police officers put on cars, right? Well, on the self-government side of the equation, consider what the Constitution insulates from democratic politics, from politics in the pursuit of the common good. Not much, very little. It insulates those liberties, those rights most essential to free societies, like free speech, press, religion, assembly, petition, self-preservation rights in the Second Amendment, and due process rights. Other than that, the Constitution leaves most other things to the democratic process precisely because the founders expected we would pursue the common good and evolve and progress over time. Therefore, so long as we the people today, okay, here and now, not as a matter of blind veneration to the founders, to the past, but today, continue to believe, agree, and accept that the Constitution of our founders, as it's been properly amended, of course, continues to strike a successful balance between self-government or the pursuit of the common good and liberty, then that Constitution, I submit to you all, is legitimate and therefore binding as a whole, whatever its imperfections. Because the point is important, I'm going to try to restate it one more time in a slightly different way. There must be something that makes a constitution legitimate and therefore binding, right? It can't possibly be that no constitution is ever binding. We know that can't possibly be true. It's never been true. Society would fall apart, okay? But on the other hand, it can't possibly be that a constitution is binding only if it says exactly what you personally would want it to say, were you the sole drafter. There must be a middle ground, something that makes a constitution legitimate even in the face of disagreement over its particulars. I claim that that middle ground is this threshold success in balancing self-government and liberty, even if it's not the exact balance you would strike. So to conclude the argument, if the Constitution is legitimate and therefore binding, we interpret it, all of it, as we interpret any other binding legal instruction, including those particular statutes we don't like. namely with its original public meaning. So what, again, is the connection between originalism and the common good? Well, as should now be clear, the Constitution is a balancing act. It is a balancing act between the pursuit of the common good on the one hand and preserving liberty as a protective measure against the many previous attempts at achieving the common good that have ended in majority tyranny. Our Constitution is a balance between the two, and only originalism preserves that balance. Thank you.
Wonderful. Thank you very much, Ilan, for those remarks. Next, we'll hear from Josh Hammer.
Thank you, Judge Oldham, so much. Thank you, Houston Lawyers Chapter, Austin Lawyers Chapter, two of my very favorite lawyers chapters. I'm obviously a partisan of the Dallas Lawyers Chapter, but definitely a huge fan of our fellow Texas chapters. So this is obviously kind of the hot discussion in originalism, in legal scholarship, legal commentary circles right now. So it's truly a pleasure and honor to be a part of this. You know, I'll start off just by saying I obviously echo and agree with the overwhelming majority of what Ilan has said. I mean, the basic claim of originalism seems almost too axiomatic, seems too self-evident to bother to repeat. I mean, when you look at a legal text, if you were to ask a kindergartner or a first grader or a second grader, how would you try to understand a text, a document that you were trying to read? I think even someone of that age would be able to fairly easily and readily intuit that the proper way to do so is to try to divine what was meant to be conveyed by the people who wrote that document. It is not a particularly outlandish claim. It is a fairly simple claim. And the interpretive, the hermeneutical truth therein, I have yet to see effectively rebutted by some of these other emerging schools of thought. But I want to take a step back here and just kind of talk about what is, you know, the elephant in the room and someone's name who hasn't been mentioned yet, which of course is my friend Adrian Vermeule. And Adrian, of course, is the reason why we're all here. I know some people perhaps rather not say his name, or perhaps it's kind of like Lord Voldemort in some of these, it's some of our circles. But Adrian is a friend, and I remember I spoke at Harvard FedSoc back in March. We got coffee for about an hour and a half afterwards, and he told me about this essay he was writing, and I was very excited for it. So here's what I want to say to people who are on this webinar right now. This is kind of the ultimate message that I want to convey. Adrian is onto something. And he's onto something for reasons that I'll explain in just a couple of minutes. But the response from people who are on this webinar, who are on this Zoom, who care about the Federalist Society, who care about originalism, who care about the normative value of the US Constitution, the response is twofold. One is to kind of just brush it aside and say, oh, he's, a crazy curmudgeon up in Harvard and he's not going to get any acolytes, no one's going to follow him. Or we can take seriously his arguments, try to incorporate some of what he's saying perhaps into our arguments, and then attempt to convey a substantive message that might win over young lawyers and law students anew. And, I think the value add that I bring to this panel, I'm obviously, unlike Frank and Ilan, I'm not an academic, but I do kind of dabble in the realm of, general political observance and commentary, and I kind of live in the conservative world more broadly. So I think, and I discussed this a little bit in my response to Adrian, an essay that I called Common Good Originalism at Claremont's American Mind website. But I think it's important to contextualize this discussion within the broader range of what is going on in the conservative world. In 2016, when President Trump was elected, he obviously was a wrecking ball of all wrecking balls, destroying with him many sclerotic, outmoded orthodoxies and consensus that many people perhaps thought were indestructible, but nonetheless proved more easily destructible than they perhaps thought they'd be. But in the wake of that, there's been all of these obviously competing strands of people trying to claim the mantle of the so-called new right, of what a forward-looking conservatism looks like going forward. And this is the context for the now infamous debates last year between David French, who at the time he was National Review, now writes for the Dispatch, versus Sohrab Ahmari of the New York Post. Kind of on the former hand, you have this more kind of classical liberal individual rights centric approach to politics and law as discrete disciplines, versus a more common good justice oriented approach on the latter hand. And that is the context in which Adrian has delivered this message to us, what he calls common good constitutionalism, an unabashed, substantive, moralistic reading of the document, And again, I don't find it truly compelling for a lot of the reasons that Ilan has outlined. It just seems so obvious to me that the original meaning of any text, whether it's a contract or a constitution or statute or regulation, any legal text, it seems to me that to have some sort of exegetical legitimacy, it must have some relation to the original meaning and what it meant to people who ratified that document. But what we should do in response to Adrian, I would contend, is to seriously grapple and wrestle with these ideas. And my basic claim is essentially as follows. A lot of originalism and originalist discourse, I think, has gotten completely unmoored over the last 15, 20 years. If you look back to kind of what animated the founding of the Federalist Society in the early 1980s, of course, it was opposition, of course, to Roe and Griswold and a lot of these aggressively activist, socially liberalizing, individual autonomy, maximizing decisions, and related to the social conservative culture war issues. I think back to Ed Meese, Ronald Reagan's Attorney General. When Ed Meese was asked repeatedly, when he was serving as Ronald Reagan's Attorney General, if Ed had one case to overturn, what would it be? He always said Miranda versus Arizona, actually. So not a culture war issue per se, but a law enforcement issue. But my contention as someone who was kind of grown up, so to speak, in Federal Society world. I was a 3-year board member at U Chicago Law, obviously a founding chapter of the Federal Society. I'm a campus speaker today. We have really gotten untethered from our moralistic roots. I think we have been co-opted by a strident strand of aggressive individual autonomy maximizing libertarianism that talks about gutting the administrative state as a goal of all goals, that talks about a lot of making allies with the cultural left on a lot of culture war causes that the original founding generation of Federal Society legal eagles would have held dear. And I think we need to kind of return a little bit more to our roots. And those roots, by the way, that's not a crazy claim. If you look at the preamble of the US Constitution, if you look at the substantive normative reasons that the framers told us they were drafting and ultimately ratifying this Constitution, they told us right there in the preamble. And you can read it for yourself, but pretty much all of those, with the possible exception of securing the blessings of liberty, by the way, being a word that to modern kind of licentious-oriented ears means nothing whatsoever to what it meant to the founders. But holding that blessing of liberty perhaps aside, all of the other substantive criteria enumerated in the preamble, providing for the common defense, promoting the general welfare, establishing justice, these are Aristotelian moralistic claims. So our Constitution, I think, as constructed, is inherently a common good constitution. And this, of course, makes sense if you think about, in particular, John Jay, Alexander Hamilton, John Adams, James Wilson, John Marshall. These were all kind of early founding era luminaries who intuited, as Edmund Burke himself actually intuited, that the American constitutional order was best understood not as a radical Tom Paine Jeffersonian French revolutionary radical experiment in Western constitutional self-governance theory, but as a restoration of the English Constitution that a monarch and a parliament gone rogue had essentially neglected to afford the protections for the colonists. And that common good tradition does go back to English common law. And what I outlined in my essay response to Adrian, and what I'm going to eventually flesh out a little more when I have time to do so, is I think we need to really rediscover that common good oriented, common law centric constitutional jurisprudence. And I'm not going to pick too much on the Federal Society, because I obviously love the Federal Society. I'm a proud member today, and we're on this webinar together. But something as just as symbolic as the fact that James Madison himself is the silhouette for our organization, I have a bone to pick with that. As I said in my essay, I think that Alexander Hamilton and that kind of John Marshall Hamiltonian, more Anglophilic tradition actually is our true conservative originalist inheritance today. And I talk about McCulloch versus Maryland as being a necessary and proper clause, concrete example of how a more expansive constructionism was actually the true conservative, common law centric constitutional inheritance, as opposed to kind of the strict constructionism of Jefferson and Madison. But these are all kind of getting in the weeds perhaps a little too much for purposes of this call. The broader claim, and one that I really want to get back to and emphasize, is I would just encourage everyone listening to think about what Professor Vermeule has written. And we need to contextualize this, of course, in the context of the looming decisions from the Supreme Court on Title VII, which is what is kind of lurking in the background here all along. There's a lot of rumor mongering. A lot of people seem to fear that Justice Gorsuch perhaps might side with the liberal bloc in the Title VII case, which technically is a statutory case, the textualism case, non-originalism case. But the broader claim of people like me and like how the Arcus has written this any number of times is that when originalism gets so bogged down in a positivistic approach to the law qua law, when we talk about not staring at the moral truths that lay there beneath the text, I don't think we're actually doing originalism right, because originalism, as it was understood by the founding generation, was not a purely positivistic legal interpretive enterprise. It entailed substance. And I think the originalism that we need to promote moving forward, that will not just kind of fit with the broader conservative movement zeitgeist of so-called common good conservatism, but is also the actual, as a historical fact, our true inheritance, what we actually took from the English common law tradition and what prevailed at the American founding, as seen in the jurisprudence of John Marshall and indeed Justice Story, is a common good centric, moralistic constitutional interpretation that did not shy away from staring at the moral truths that lay beneath the text. And I would just encourage everyone on this call to think very hard about that and to just try to shy away from pure positivism, pure qua positivism. So thank you very much.
Wonderful. Thank you very much, Josh, for those wonderful comments. I think we're having some technical difficulties with Frank Buckley. We're going to try to get him back. In the meantime, I'm curious, Ilan, if you have any responses to what Josh had to say.
Yeah, well, it would be a poor sportsmanship if I didn't agree with most of what he said, since he agreed with most of what I said. So I'll say, I agree with a lot of what you say, Josh, though I'm skeptical that it has to do with constitutional interpretation so much as politics, right? That economy versus common good and so on. But because we have Frank back, how about I save the rest of the comments for after?
Well, yeah, thank you very much, guys. I apologize for that. I blame Comcast. And my apologies in particular to Josh Hammer. I'm sure what he said was absolutely brilliant and that I'd have no answer for it whatsoever. But, as I didn't hear him, I don't have to respond to him, right? And I also thank everybody for letting me in, because I'm very much the interloper. I'm not the con lawyer that everybody else here is. I'm a private lawyer, and indeed the only con law I ever took was North America Act in Canada, so I'm very much the outsider. But as an outsider, I looked at the arguments for originalism, and whilst I was very sympathetic to, I think, their objective politically, yet I found the arguments really quite unpersuasive, and let me try to tell you why. So what are the arguments for originalism? Firstly, the argument from certainty, right? So it goes like this. What you've got is the fixed star of the framers' constitution versus a big bowl of shapeless jelly in which Judge Andrew Oldham and other judges play. And I don't buy that for a couple of reasons. One is, let me state this right off, I like the idea of reversibility. I like the idea, I'm a bit of a Hayekian, so I think that experience should really be our guide. And in that, I'm quoting John Dickinson at the convention. Dickinson was a Hayekian avant la lettre, and I think people there would have agreed with him. And if that's the case, originalism wouldn't unwind of itself. And then apart from that, you have the illusion that originalism offers greater certainty. Now, I didn't hear Josh, but I had the sense that there was a disagreement between Josh and Ilan. And if that's the case, so much for certainty from originalism. But even apart from that, right? Zephyr Teachout thinks that Citizens United was wrongly decided. Zephyr Teachout is an originalist. Bruce Fine thinks that every war we entered into in the last 60 years was illegal. Bruce Fine is an originalist. Roger Pilon is a libertarian, like most folks at Cato. Roger is an originalist, right? So if originalism means all those very different things, it really doesn't mean very much at all. Secondly, and here I'll respond to something that Ilan was talking about, that we're bound to the Constitution because it strikes a proper balance between self-government and liberty, to which I'd say nonsense. That's not why I'm bound. I actually don't think the American Constitution does that. I think the Anglo-Canadian system of parliamentary democracy does so much, much better. But all that's irrelevant, because the reason why I'm bound to the Constitution is because I took an oath of citizenship. I did it on tax day, April 15, 2014. That made me a citizen, whatever I thought about the Constitution. So it seems to me that Ilan has tried to give jurisdiction and citizenship a weight that they can't bear. If Ilan became a Venezuelan or a Russian, he'd be bound to support their constitution. I think Hannah Arendt had it right. You're bound unless the Constitution is so immoral that you have a right of revolt, as, for example, the fugitive slaves did when they fled to the freer countries of Mexico and Canada before the Civil War. Then you have the idea of the normative superiority of the Constitution. Right. Well, but what Constitution, firstly, are we talking about? I mean, there's so many of them I've seen so far. But even if what we're talking about is Roger Pilon's libertarian Constitution, I don't buy that either. I'll tell you why. I mean, if you're bound because of the normative superiority of the Constitution, what do you do about the Fugitive Slave Clause and the Fugitive Slave Acts before the Civil War, right? What exactly is the status of the framers between 1789 and 1865, right? Are they simply chopped liver? I don't buy it. Secondly, and here I draw on my experience from Canada, I rather like the idea of a living constitution if it departs from the original text in a way which promotes liberty, as the Privy Council did in a Canadian decision involving federalism. The founders of Canada, the fathers of Confederation, wanted a very centralizing document. The Privy Council took a look at that and said, right, we actually like decentralization. And as it's the case, I believe, that Canada is much more a robust federal state than America, I rather like what the Privy Council did in that respect. And then let me mention one last thing, the incorporation doctrine. It seems to me if you're originalist, you must be opposed to the incorporation doctrine. Curiously, however, some prominent originalists also object to the Blaine amendments. I don't think you can do that. I don't think you can suck and blow at the same time, right? The thing which really gets me about originalism, however, is what seems to me to be their hubris. I mean, the idea is, I guess I'm here speaking not so much to Ilan as I am to people like Roger Pilon, right? The idea is if we can't win democratically, we'll do it constitutionally, right? I mean, that's never going to persuade your opponents. It won't persuade me because I'm not an originalist, right? But observe how much that resembles the undemocratic liberal clerisy now atop our academic legal institutions, right? What that kind of originalist would want to do is replace one elite with another. He doesn't object to the means, he just wants to be able to run things his own way. The counter-majoritarian problem is the same. Constitutional law, as I see it, should be divorced from politics. A colleague of mine once in a debate told me that he preferred the American Constitution to the Canadian one because there is a scheme of Medicare in Canada and not in the United States. Well, even leaving aside the fact that I prefer the socialized system of medicine in Canada to the socialized system of medicine in the United States, I don't think that's how you do constitutional law. I suspect I agree with Ilan here, right? I think what you do is you set the thing in motion, and then you're rather agnostic about how things turn out, whether it's for or against Medicare. So constitutional law, as I see it, should be divorced from politics. That is to say, I'm not an originalist. There's another question here about which constitution, public meaning, original intent. I'd argue for original intent, but I think it'd be better actually to stop right now and get into discussion.
That's wonderful. Well, thank you very much, Frank, for your remarks and for getting back so quickly. It's a wonderful contribution. to the conversation. And to Josh, obviously, some of the things that you might think don't merit discussion about original public meaning originalism obviously do. So we can continue that conversation with Frank's healthy skepticism, I think. But why don't we start with something that I think all three of you brought up, which is this notion of why are we bound? So Ilan, you talked about that. Josh, I know that in your back and forth with Professor Van Mule, you talked about that, and obviously Frank has a third view. So why don't we just go in order, Ilan, Josh, and Frank, about and respond to one another, or to Professor Vermeulen on the so-called oath-taking problem about the Constitution and its legitimacy for bindingness.
Yeah, thanks for those remarks, Frank. Now we've got ourselves a debate. And so I have 5 points in response, 2 of which relate to Judge Oldham's prompting. So I'll start with those. You say you're bound by the oath. Okay, so be it. There are lots of scholars, and I think I saw Professor Green at Ole Miss on this call. He has an argument about the oath clause creating this, what are you taking the oath to this Constitution, and what does that imply? Well, all the sorts of things I said about public instruction. So if you're bound for that reason, then fine. Then you should be an originalist when it comes to interpreting the Constitution, right? Which sort of brings me, to the. Actually, I guess I have 3 points. So it brings me to another question, which you said, originalism isn't the only system that has certainty. I agree with that. I agree with your point about this. The common law Constitution can have certainty. Judicial opinions create certainty. A judicial opinion written by a non-originalist judge is interpreted how? Well, with its original public meaning. The point is, some legal text purports to create our legal obligations that we're supposed to be bound by, and how do we figure out what it requires of us? We interpret it with its original public meaning. The question is, are we bound by the original public meaning of judicial opinions? Do judges get to make the law? Or are we bound by the original public meaning of what we the people enact into law, whether in statutes or the Constitution? None of that assails the proposition that original public meaning is how we interpret these texts. It goes to the question of, what is the legitimate source of law and legal obligation in our system? Do judges get to make it up, and therefore we're bound by the original public meaning of their opinions? Or are we bound to something else? And I think we're bound to something else. So which brings me to the third point I want to make, which I touched on, this legitimacy questions, this binding questions. You raise the very problematic example of the fugitive slave clause and the accommodation with slavery. And I'll say 2 things in response to this, because it's a common criticism, and we've heard a lot about this in the 1619 Project now. Well, the first thing I'll say, you'll note that I didn't say that we're only bound by the Constitution today. If the Constitution of 1789 or 1791 was legitimate in the sense that we believe it needs to be, I said if we the people today believe that this Constitution balances self-government and liberty, then we're bound even in the face of disagreement. And lo and behold, our Constitution no longer has the fugitive slave clause. It no longer has the 3/5 clause, right? Because we progressed and evolved over time. We realized that this precondition, the self-government and liberty, today, as we understand it today, was insufficiently met by the old Constitution. And so we carried the Constitution along with us. We progressed, but we brought the Constitution along with us. And the only thing I'll say, the other point about this, is we have to be wary of what the admittedly socialist historian E.P. Thompson famously described as the enormous condescension of posterity. Okay, it's very easy to sit from our modern day perch and criticize the founders for all of these accommodations they had to make with slavery. But what was the alternative? What was the alternative? A Southern Confederacy from the get-go in 1788 and 1789, that over which the North, the United States of America that excluded the South, would have had no control? Was disunion going to be better? Because disunion was still going to have slavery, right? Slavery pre-existed the founding. Slavery was there. Slavery was a constant. Slavery was not invented by the founders. Slavery was a condition, a reality that they had to deal with. And I think the Constitution that they created was an improvement of such importance and magnitude upon the conditions that they were confronted with, upon the state of the world that came before, such that if I were living in 1789, I would be bound by that Constitution. If I were a slave in 1789, I don't think I would be bound by it, because it obviously doesn't successfully balance my self-government and liberty. And of course, the slaves had every right to revolt, every right to revolt. But otherwise, the Constitution has to be judged by the principles of its time. And if today's Constitution was still that Constitution, sure, we shouldn't be bound by it, and let's change it. Let's have judges do it.
Great, Josh. What do you? Thank you very much, Ilan. What do you think on the topic of binding?
So the oath debate is somewhat tangential to this, and I'm almost bemused at just how much attention it has gotten. I remember when I was in law school, it seemed kind of like a very, very nerdy, esoteric side debate within friendly originalists, kind of just debating one another. So it's very funny to me to see Cass Sunstein running Bloomberg columns about this now, and this debate of all topics somehow making seemingly national headlines, or maybe not actually national. We may all just live in a bubble on this webinar, which is probably true to one degree or another. But in any event, look, I mean, in my initial essay, in my response to Adrian, I advance some of these oath theory claims. I mean, I guess I'm basically a weak oath theorist. I am not fully persuaded that the words "this Constitution" in Article 6 require what today we would call original public meaning originalism. But what I am more confident about is that when you take that solemn oath of office, so help me God, to this Constitution, and Chris Green of Ole Miss Law School, Ilan just mentioned him. I do think he's made some very important points on this. If you look back at the Constitution, there are some pretty clear indications in there that this Constitution was referring to a specific time and place. And of course, the importation of slave clause with respect to 1808, they mention an exact year. That's a pretty telltale giveaway that the words "this Constitution" probably do refer to what was drafted at that time. Because even today, when you take that oath, you're taking an oath to a document that has the 1808, that year, right smack in there. So there are some clues in there. And more generally, it seems to me that Michael Stokes Paulson is onto something more broadly. And this kind of gets back to what I was saying during our first roundtable of remarks, that the very idea of written constitutionalism entails a hermeneutical, exegetical inquiry into understanding what was ratified at that time. Again, that does not strike me as a particularly broad or crazy claim. But there's something else here. I mentioned kind of inheriting the common law tradition on the last time, and my kind of Anglophilia is not bursting through the scenes more generally. But Ilan mentioned something that's really important here. Even before the Constitution, in the English constitutional order and common law judging, this was not kind of a continental Hegelian Germanic approach to the law. At common law in England, even though there was no written constitution, judges thought that there were, quote, right and, quote, wrong answers. They did. And the way that they obviously discerned that was through kind of the empirical common law tradition, which was ultimately rooted, as no conservative icon lesser than Edmund Burke told us repeatedly, that common law tradition was ultimately rooted in the higher axioms and subsidiary principles of natural law. With respect to slavery, and obviously that being kind of the original sin, it's kind of the 1619 Project and all of that. Look, I always think of this similarly to how Abraham Lincoln thought of it. Lincoln quite famously said that the Constitution was just the frame of silver, and the Declaration was the apple of gold to go within the frame of silver. Now, when Abraham Lincoln responded to Roger Taney's monstrous decision in the Dred Scott case by vowing not to enforce it except for Dred Scott himself, and he actually issued passports to free blacks in the territories in direct contravention, of course, of Dred Scott. He was appealing to those axioms or subsidiary principles of natural law. He was appealing to the Declaration of Independence. And as a positive law matter, it's obviously true that it didn't take until the ratification of the 13th Amendment to formally eradicate that horrible, horrible, horrible stain from our constitutional order. But it was these pleas to the natural law. And Lincoln didn't just do it in Dred Scott. He actually had very similar rhetoric with respect to the Fugitive Slave Clause. He chose to interpret that clause in light of the natural law. I don't have the quote in front of me, but it's pretty revealing if you look into it. And that tradition of natural law undergirding how we think about the Constitution, how we ought to interpret the Constitution, is what I think I'm trying to get here and what I'm calling common good originalism more generally.
Great, thank you. And last but not least, Frank,
Okay.
I realize you've taken some arrows on it.
Well, great. I'm sorry if I led people to start talking about the oath debate, which I find entirely without merit. The problem with the oath debate, to the extent it's a debate, is it tries to sneak in an idea about the content of the Constitution, right? What they want to say is you violate the oath if you don't support this particular Constitution. Well, look, there are plenty of different constitutions out there, so the oath debate doesn't get us very far. What I wanted to say was, in opposition to what Ilan had said, is I was bound by an oath, or one being born in America is bound as a natural born citizen, and merely to make the point that you can't put any normative weight upon that unless you think the Constitution is absolutely so horrible that you have the right of revolt. Second point, look, originalism is simply a canon of interpretation. And if it applies generally, not just in one country and not in another, and not just in one time and not in another. And therefore it applies with respect to the Fugitive Slave Clause for 70 odd years, 1789 to 1865, right? The 1619 project is not entirely without some historical basis. If you read people like Alan Taylor or Simon Schama, and you try to figure out who was on the right side in 1776, then I think it's a rather more complicated story than many people think. But I would say this of the 1619 project, that it's so inconsistent with any idea of reverence for the country you live in, that it's wholly destructive of nationalism. Why, in short, were that project correct? Why would anyone want to live in so infamous a country as America? It doesn't make sense. Lastly, on public meanings, I wanted to argue for the necessity of buying into the intent theory. That is, that what matters is not just the words, but the meaning that the framers would have given to them, for a couple of reasons. Firstly, this is what Blackstone recommended, and the framers read Blackstone. Moreover, many of the framers, 4 of them, ended up in the Supreme Court: Wilson, Rutledge, Patterson, Ellsworth, right? They didn't have to think too much about public meaning per se, right? The intent of the framers was built into the jurisprudence of the Supreme Court from the very beginning. Think of it as something like apostolic succession. And finally, the problem of originalism in one country. I mean, originalists roughly seem to subscribe to the "we are Klingons" theory of comparative constitutional law. We don't have to pay attention to other constitutions. But I think you do, because, as I say, you can't have originalism at one time and not another, originalism in one country and not another. So what do you make, therefore, of Section 9 of the British North America Act of 1867, which vests the executive government and authority over Canada in the Queen? So the public meaning of that is pretty clear. The public meaning is that Queen Elizabeth should be ruling Canada pretty much the same way that Charles I ruled England. That is obviously not what the Fathers of Confederation wanted. So, looking at that, it seems to me that the intent of the Fathers trumps whatever the public words are. Our problem with originalism, in short, is the tendency to see it as specifically applied to one period of time and not another, to one country and not another. That's not how you do canons of interpretation. You don't have an eustem generis rule for Canada and not for the United States. You don't have an eustem generis rule for 1800 and not 1865. It doesn't work like that. You have to buy the whole darn thing. And I don't do it.
Can I don't know. Yeah, jump in there for a second. I mean, there's a lot still to respond to, but I know we want to get to questions. So I'll just respond to this one country problem. Like, there are plenty of other countries that have written constitutions that aren't originalists, and therefore originalism can't be right. I think that's a crazy argument, okay? Originalism, frankly, I disagree. is not actually a canon of interpretation. Originalism is a theory of law, okay? It is a theory of where law comes from. It is a theory of what law binds us. It is a theory of what are the legitimate sources of law. Even in, as I said, okay, even in those countries like India or Canada that have ostensibly written constitutions, but that judges, do whatever they want with them, right? Something commands people or legal officials to not do things, to do things, and those texts are given the original public meaning, right? Because they're instructions. It just happens to be that they interpret the judicial opinions with the original public meaning of the judicial opinions to figure out, okay, what does the judge tell me to do? What is the law here that the judge is saying or creating? So it's a theory of law. If a country wants to have, if we want to have a written constitution that judges kind of sort of look to as sort of a general guiding principle, but ultimately they're allowed to deviate if they want, fine. Then that's a legal system where we'll give original meaning to some other text, the judicial opinions. And that's just, again, it goes to the question of what are the legitimate sources of our law and our legal system? What the judges say it is, or what we the people say it is through congressional enactments and the constitutions that we ratified. So the fact that other countries have different theories of law, of what's binding law and where law comes from, well, America is exceptional, as we always say, and I've always thought in a good way.
Great. Well, why don't we, I'll ask one more question while folks are queuing up, but we can go ahead and open. The chat box is open, so feel free to submit questions by chat, or if you want to raise your hand, April will call you and we can activate your microphone and you can ask your question live. But while folks are queuing up, one final question for the panel that I'm curious about is, one of the things that Justice Scalia used to say about originalism, and the reason that he preferred it as an interpretive methodology, was precisely because it did not dictate a particular outcome in a particular case. So he would often talk about, for example, he thought the Crawford line of decisions regarding the Confrontation Clause was dictated by the original public meaning of the Sixth Amendment, even if he didn't like the results in those particular cases. And so he would often pair that with by saying that the judge who likes the results in every decision that the judge reaches is not a very good judge. But it strikes me that a lot of what Professor Vermeulen and some of this discussion about the common good is really getting to is, as I guess Randy Barnett in contributing to this discussion has called living constitutionalism of the right. That is that judges or academics or lawyers are injecting into the Constitution now things that really have nothing to do, like as soon as we move past the original public meaning of the document as it was adopted by the people, that it's sort of the wild, wild west, and we can put into it whatever our conception is of the common good. Is that better or worse than the original, as Professor Vermeulen put it, the original originalism that seemed to be his foil. So I'm curious about your thoughts about what happens when we move beyond understanding the document as was originally adopted.
I could take that if no one else does.
Sure. Go for it.
Yeah, so look, I think that on the extreme, on one hand, you have kind of this pure positivism that is, most frequently associated with Judge Bork, Justice Scalia, and kind of an earlier generation of originalists. And that's kind of what we heard there, in that quote. I mean, Scalia, I think, used to joke that he had a stamp in his chambers where he would stamp a lower court appeal and say stupid but constitutional, right? So, I mean, his entire kind of jurisprudence was ultimately undergirded by this belief that a judge who always reaches his or her outcomes is probably not judging correctly. And there obviously is something to be said for that. Since this whole conversation started, I've tried to, I've actually myself thought about whether there are cases that, I just abhor the policy outcome, but think came out, the opposite way in my policy. And I think back to the Scalia versus Thomas divide in Gonzalez versus Reich, the marijuana case out in California, if I believe it was. I look, if I had my druthers, as a common good centric conservative, I would ban every narcotic in the country, full stop, period, no exceptions whatsoever. I nonetheless think that Justice Thomas's dissent in the Reich case is almost assuredly correct and is reconcilable on necessary and proper clause grounds with Marshall and McCullough. So all that to say, kind of a roundabout answer to you, Judge Oldham, I do think that is correct. I guess the claim that and I'm still fleshing this out, what I'm trying to call this kind of new subgenre of common good originalism, and by new subgenre, I'm kind of trying to lay claim to kind of the common law Burkean Hamiltonian tradition of thought, is that when originalism does not necessarily always provide one answer, but when it narrows the bandwidth sufficiently, and when the interpretive bandwidth is narrowed such that there is a much narrower stream, or whatever you want to call it, of plausible outcomes, then perhaps we should look at the preamble and look at the fact that the overwhelming majority of the substantive normative reasons that we are informed for this ratification of this Constitution are what I would call, in today's terminology, common good oriented terminology. Then within that originalist interpretive bandwidth of possibilities, we ought to then normatively kick in and perhaps err on the side of the common good over maximizing individual autonomy at the expense of individual autonomy. And that kind of does get back to political theory. So I actually do ultimately disagree a little bit with Frank. I have never thought that constitutional law and politics or political theory can ever be truly severed from one another. We are talking about the ultimate goal here of crafting a charter for generations of human beings. Jefferson famously used to say that the Constitution was around for 15, 20 years, and they would just rewrite it. That's not a particularly conservative approach to the art or the craft of writing a Constitution. So this entire enterprise, in my mind, is inevitably intertwined with politics to some degree. And I think Adrian is onto something when he says that. What I've tried to do, and what I would encourage others who are listening to think about in their own capacities, is to try and find some sort of middle ground position between accepting that basic human truth, that interpreting a text cannot avoid the underlying moral questions embedded therein, and on the other hand, staying true to our Anglo-American tradition. Again, as I said in the previous segment, going back to common law judging absent a written constitution, of interpreting law and making law where there is such a thing as right and wrong answers. Those are the two things that I am trying to find a neat solution to, and I would encourage others to try and do the same thing.
Great. Frank, did you want to go next?
Yeah, a short one. So that's what you were saying, Josh. Okay, now I understand. I think I'll agree with Ilan here that common good theories are a theory of politics and not of constitutional law. That it's really, what we're really talking about is what the legislator or the executive should be doing in these circumstances. I don't want to get into Vermeule, who's both attractive and repellent, and who I've faulted for not paying sufficient attention to the origins of his religion, actually. I'm a fan of Sir Larry Siedentrop's book, Inventing the Individual, and think that modernity was invented in AD 30, and that the roots of individualism and democracy can be found in the Judeo-Christian tradition. So, but one thing that's amusing about all of this, look, I began when there was something called the crits. And these were people, very left-wing, who wanted to attack all the assumptions behind the bien-pensant law of the time. And now there are crits also, but they're right-wing crits. I find that amusing.
Can I say one last thing, super short?
Yeah, of course.
I agree with Frank on this general point, Josh, that again, the common good mostly plays a role by allowing, right, the Constitution allows us through the realm of democratic politics to have, libertarian results, conservative results, liberal results, progressive results. Some things are off the table, but most aren't, right? And that's where the battle for the common good is had. But that's not to say it has nothing to do with whether the Constitution itself is legitimate. Obviously, my argument about self-government and liberty, right, that's a conception of the good too, right? It's just a much lower threshold, right? It doesn't have to be perfect, it doesn't have to be utopia. It has to do this balancing of self-government and liberty, even if you don't think it's perfect, and then let us play out for the common good down the road through ordinary law and democratic politics. So it plays at both levels, ordinary politics and constitutional politics, but it's much less demanding at the level of constitutional politics.
Great. Thank you very much for the wonderful discussion so far. April, do we have anyone from the audience to participate?
We do. And just as a reminder, if you're joining us by phone and you'd like to dial in with a question, hit *9. We've already got a number in the raised hand Zoom queues and in the chat. So we will try to get to as many as we can. We've got to stop at 1:30, but we'll field some questions until then. Michael Massengale from the Houston chapter, you're up.
Okay, can you hear me?
Yes.
Great. Well, thanks for this really stimulating debate. And Josh, I wanted to particularly compliment you for getting Professor Vermeulen to engage with you. I've been grappling with a lot of the same things that you've been talking about. And I wonder, I'm somewhat mystified why he's perceived as such a threat so as to instigate panels like this. And so I wonder, would you agree it's fair to characterize Vermeulen's arguments as essentially bypassing this debate that we're used to having about interpreting a written constitution, and he's instead driving towards a more fundamental legal or constitutional reform? And if that's right, can't one sympathize with Vermeulen but still embrace and advocate originalism as the superior framework that lawyers and judges who have the job of trying to resolve particular disputes, the best tool for them to use, and understand Vermeulen's contribution basically as a philosophical argument about the government we ought to have rather than an argument about the government that we do have?
So good to hear from you, Justice Massengale, first of all. I hope you're well and safe amidst this terrible mess. So I think there's a lot to be said for what you said there, obviously. Adrian, politically speaking, is an integralist, right? I mean, this is no secret. He has written this numerous times. I think his ideal political form is a Catholic monarch. Again, he's written that. That's not like an open state secret or anything like that. And that kind of obviously has perhaps some substantive effects on his thoughts on the administrative state and various other parts of his constitutional theory. I do think that he is ideally advocating for a new form of government. I don't think that's a particularly shocking insight. I think most people who read his essay would come to the conclusion that his ideal political order is not one that was necessarily the founder's vision. And I do think that for those of us who, as a normative matter, generally think that the framers, by and large, got it right, which has been my stance my whole life. That's part of the reason I joined the Federalist Society as a first-year law student at the University of Chicago Law School. For those of us who normatively believe that there are truths about human nature, to get back to Madison, Federalist 51, ambition must be made to counteract ambition, all those good sound bites, that there are fundamental generational truths going all the way back to Aristotle and Plato and whatnot, that the framers, by and large, were able to encapsulate and distill into our written charter. We do have some sort of an obligation to be faithful to that text. The higher level debate, which I think has undergirded the entirety of this webinar, it's kind of lurking in the background, I think, of your question, Justice Massengale, and is really lurking in the background of this entire national discussion that Adrian has helped launch, of course, is what is law? And, Adrian, he has a certain fondness for Schmidt and various other thinkers of the Germanic legal tradition. I think the Germanic legal tradition, continental European views on what is law as an underlying interpretive enterprise, does differ substantially from the Anglo-American tradition. And, as we've said repeatedly on this panel, I think it is an Anglo-American conception of the law to think of the law as having, generally speaking, right and wrong answers. And that was true at common law. That's true in our constitutional interpretive confines today. That is different than what Adrian has put in his essay. And he'll have to flesh it out, obviously. I entrust that he will. But that ultimately, at a 35,000-foot altitude level, is what's really going on here, I think. There is an Anglo-American conception of the law as having right and wrong answers, and a more continental European, really centering along Germanic school of thought of what law is, as not necessarily being tied down to right and wrong answers per se.
Great. Either Frank or Ilan, anything to add? Great. April, should we take another one from the audience?
Yes. Gideon Lazar.
Can you hear me now?
Yes, we can hear you now.
All right. So I just wanted to thank you guys for having this excellent panel. I think this was a great discussion. My question is to Josh Hammer. I have a lot of friends, and I'm fully in agreement with you, but I have a lot of friends who are much more in line with Vermeulen's position and say, look, we tried this whole originalism thing. We gave it a shot. We had, as you said, for example, the last generation of the Federalist Society was much more socially conservative than the current one. And so we tried it, but it failed. We still have Roe v. Wade. Now we're having Drag Queen Story Hour. Soon maybe we'll have something like legalized pedophilia. What's coming next? And so ultimately they say, we gave it a shot, it's failed. Let's try something new like Vermeule's strategy. And maybe in an ideal society, we could have something nicer where we can have this nice constitutional system. But right now, stuff has just gotten so crazy that we need to do anything that will work to save the common good.
Yikes. Yeah, no, look, I hear that. I hear that loud and clear. I was having a chat 5 or 6 years ago with a friend who I will not out him on this national webinar, but, Harvard Law, FedSoc, multiple appellate clerkship, close friends. And we were talking about this 5 or 6 years ago, and he was already on what I'm kind of going to call cynical, nihilistic originalism, basically just saying the left is already doing this. Why are we trying to tie our hands behind our back? And, look, if we're looking objectively at the history, the post-1982, post-Federalist Society founding Supreme Court era history, it is a history over and over again of the liberal bloc on the court voting in lockstep with one another. They know where their bread is buttered. They have an inherently outcome-oriented jurisprudence, and all it takes is for them to pick off one Republican nominee. And we've seen it over and over again how that plays out. It generally does not redound to the interests of conservatism. And generally, I would argue does not redound to the interests of America's constitutional order. I guess what I would plea to you, Gideon, and I hope I'm pronouncing your name correctly, to tell your friends who are kind of already in Adrian's camp, perhaps you can think of like what I'm discussing in the conversation that I'm trying to launch as perhaps one final effort. And I hate to frame it in like that kind of dire, stark, cynical terminology. But I don't think this ship has sailed quite yet. We really have kind of gotten unmoored, which is obviously something that I talked about in our first round of discussion here. But it is not too late within the confines of originalist discussion to get back to some of the overarching issues that animated the Federalist Society's founding. And the best part about this is that it's right there. All we have to do is go back to what Hamilton, Marshall, and Story, Joseph Story in his famous commentaries of the Constitution, it's right there for us. It's just not taught in constitutional law curricula in law schools. And people don't realize it's there because we've been told for 20 years now that to be a good originalist, we need to necessarily agree with Jefferson and Madison and all the various modes of quote unquote strict constructionism. So the roots for a moralistic, natural law-based originalist interpretive enterprise are there for us. So I would just encourage you to tell your friends to not cynically lose hope quite yet.
Can I jump in there, Judge Oldham? I guess, the thrust of your question, it seems to be actually something that Frank touched on when he was attacking, if you will, Roger Pilon, which is, look, he gets, if he can't win democratically, then they say the Constitution requires their preferred policy preference. This is true of many libertarian originalists. And it's certainly, if your method of constitutional interpretation always leads to happy endings, as they famously said of Ronald Dworkin, then there's probably something wrong with it. And it's what the progressives do, right? I mean, the progressives don't care about democracy. They only care about democracy to the extent that they expect to politically win through democratic outcomes. And when they don't, they prefer judges to take things out of the democratic process, like on abortion, same-sex marriage, and so on. The originalist position, I think, call it conservative. I don't know, it's not conservative, liberal, right? It's that all these questions play out again in the field of democratic politics. So Drag Queen Story Hour, I mean, that's a cultural battle, fight with your local town library, but the Constitution certainly doesn't prohibit a private organization from having Drag Queen Story Hour. It certainly, I don't think it prohibits a public library from doing it if the town wants that, if that's their moral values, right? So this notion that the Constitution has something to say on those questions in the direction of this common good, Catholic integralism kind of approach is a very, very, very scary notion. This notion that, well, if we can't win democratically, then we'll get our judges to do it. that might work for you for 10 years when the stars all align and your judges are in control and so on. But it's very scary in most times.
Great. And Frank, I think you wanted to jump in too.
Yeah, a little one. I'm agreeing so much with Ilan that I'm beginning to have to begin to worry about myself here. I think part of our problem here is that terms like common good or even liberalism are so poorly understood. And let me give you an example. I grew up in what was a completely integralist society, entirely Catholic, entirely French Canadian, but for me. And at one point when in school, public school, the nuns, yes, that they were nuns, talked about Joan of Arc, the nun took me aside afterwards to explain that she meant not to embarrass me because I was an Anglo on the subject of Joan of Arc, even though the English had burnt her. And from her, I learned a different kind of liberalism, which is really quite not well known. It's a liberalism of courtesy, of sensitivity, of a sense of the possibility of self-deception, things which seem to me to be entirely absent amongst some of the common good theorists who are the noisiest amongst us. There's that kind of liberalism which has nothing to do with John Locke, but which seems to me much more important and much more worth preserving than any kind of theory. No great thing ever emerged from a theory.
Great. Frank, while we're on this very topic, why don't we, I'm going to grab a quick question out of the chat because we talked about Christopher Green, who a couple times earlier, and he's also in the chat, and he asks a question about, Frank, when you were taking your oath on tax day 6 years ago, what you understood the quote Constitution in that oath to mean. So if it's not the original public meaning of it or some form of originalism of it, how did you personally understand the concept of the direct object of your oath?
Me personally, on tax day 2014, I thought it referred to the Constitution as the courts were interpreting it at the time, as you indeed would, Judge Oldham.
Very good, thank you. April, do we have anybody else in the, I'm happy to go back to the chat room, unless we have others in the queue.
Yes, actually, we have quite a few. And so I'm sorry if we don't make it to everyone. We've got a number of folks in the line. Catherine Eschbach.
Hello. Thank you all for a very stimulating debate or conversation. I understand the terminology attached to this was itself a conversation. I was wondering, to what extent do we think this conversation is premature? Are we giving up on the originalism experiment just as it's coming into its zenith? You know, President Trump just put a whole bunch of new judges on the bench who have grown up in the Federalist Society in these conversations about originalism, and they're just getting started, and we're just getting to see what a judiciary that has larger numbers committed to originalism looks like and what that results in, and whether we're in some ways putting the cart before the horse before we see the fruits of all the academic labor of the people who have laid the groundwork for originalism over the past 20, 30 years.
I'll just say I agree with that. And you know, I think Josh, in passing, you know, said the ship hasn't quite sailed, or I don't remember exactly what you said, but maybe in response to that in the previous question, I don't think we've really given originalism a go. When did we actually give originalism a go? I don't think there was ever 5 committed originalists on the court. So I agree. I agree with the sentiment out there.
Yeah, no, good to hear from Catherine. Hope you're also safe and well. I largely agree with Ilan. I think now, and this kind of gets to a higher level disagreement between myself and probably Ilan on the one hand and Adrian on the other. At the beginning of his infamous essay, he kind of begins by describing originalism in purely tactical, strategic terminology as a cudgel that was wielded against the activism of the Warren Court. That's not how I view originalism, as I've hoped to make somewhat clear in this conversation. I view it as a fundamental, higher level conception of law as generally having right and wrong answers that I think we ultimately inherited from England. So that is how I view originalism. I've never thought of it as a kind of purely tactical cudgel to kind of just dislodge. The only question that I've been concerned about is developing a theory of originalism that is not just methodologically coherent, but that forward-looking will be able to keep some moralistic social conservatives who think along the lines like I do within the tent, and that will also kind of, I think, more authentically get back to the Hamiltonian Marshall tradition, as opposed to, again, this kind of strict constructionism that I think has dominated Federalist Society discussions for too long.
All right, we'll take one more from the queue here. Lael Weinberger.
Hi. So thanks so much for a great conversation. I was wondering if I could just ask each of the panelists to give a comment on the place of natural law in their view of constitutional interpretation. We've touched on this a few different ways. And for Josh and Ilan in particular, I'm curious, to the extent that you're okay with ever using natural law kinds of ideas to inform constitutional interpretation, where does it come in? I can imagine it could be part of the context that the public in the late 18th century would have used for reading a text. It could be a tool of constitutional construction that we only employ in areas where interpretation doesn't flesh things out, if you buy kind of the interpretation construction distinction. So there are a couple different ways you could go there if you're okay with ever using it. And for Frank, I was wondering if you might comment on either that or maybe elaborate on your stated preference for a presumption of liberty of some sort, a willingness to see the Constitution evolve in the direction of greater liberty following the Canadian model that you mentioned. I take it you wouldn't like this to be termed natural law, but in a very broad sense, this does seem to me like a form of natural law, and especially if you want a law-politics distinction, it seems like some form of natural law or some other ethics has to be the information that you're drawing on to guide the evolution of the law. So if it's not politics, what is it? And so that's the short version. What's the place of natural law?
Well, we'll be able to get responses from Ilan and Josh, but unfortunately, Professor Buckley just had to reconnect, and so I'm not sure he caught any of that. But so I'll go ahead and turn it over to Ilan and Josh.
Well, we'll be sure to re-ask him the question, though, because it's a good one. And I'm tempted to say, having just watched the Clarence Thomas documentary, I have no idea what you're talking about. But that was really in the exchange with Senator Biden, and it was sort of fair in response to that, I think. But the short answer is the second option, the second alternative that you described. So I've done a pretty deep dive into historical materials on substantive due process, which wasn't actually substantive due process. It was something else. I just wrote a piece in Chicago that basically says all these cases, antebellum substantive due process cases, actually weren't substantive due process cases. They had to do with municipal corporations or where state power came into conflict with federal power, like dormant commerce clause, these negative commerce cases. And when you look at how state courts actually analyze state legislatures making regulations, they sometimes deploy the principles of natural law or natural right, the principles of free government as a rule of construction. What they would say is, well, look, if we can avoid it, kind of like an avoidance doctrine, if we can avoid it, we're not going to presume that the state legislature intended to create a result so contrary to the principles of natural law and natural right and the principles of free government. But they would say time and time again, however, if the legislature expressly said it, then we do it, right? So the short answer is, it's, and so if you think the 14th Amendment incorporates something like that against the states, I don't think it does, by the way, which is part of the subject of my next book, then maybe, it can be a rule of statutory construction, but I don't think we can do much else with it. But I'm excited to hear what Josh has to say, because I think he probably thinks you can do more with it.
So I guess there's three areas that I can see it playing a role here in. You know, the necessary and proper clause, a clause that I've mentioned numerous times now, comes immediately to mind. If you look at Hamilton Federalist 33, as he outlines necessary and proper clause, he's talking about the means-ends connection and thinking of the principle as essentially being a moral agent on behalf of the people. That's how he conceptualizes the necessary and proper clause. That to me is a natural law infused conception of the necessary and proper clause. And I think Chief Justice Marshall got that exactly right in his most famous quote in McCullough versus Maryland, you know, let the ends be legitimate, et cetera. I don't have the full quote memorized, but that's where he was getting that from. He was adopting that pretty straight from Hamilton in Federalist 33. And I think that Hamilton's approach there in thinking of the principle as a moral agent, and this kind of gets back to Ilan's notion of kind of Republican self-governance and consent to govern in the first place. That is a natural law infused interpretation of a constitutional provision, straight up right there. The interpretation construction point, I agree with that too. That's obviously a murky point in contemporary originalist discourse, and I don't claim to be an expert on it. But to the extent to which I understand it, I think it kind of connects to what I was talking about either one or two segments ago, which is when the originalist interpretive methodology can only sufficiently kind of get you a bandwidth of possible outcomes. It doesn't necessarily get you a true clarion, beyond a shadow of a doubt, one right answer, but when it can only kind of narrow the window of possible outcomes, that is when I think substantive appeal to natural law reasoning can and should overtly slide into actual judicial opinions. That is where I would encourage it and where I would expect to see. And I think we actually saw a lot of that in the first 20, 30 years of the Supreme Court. Calder versus Bull obviously is an example that comes immediately to mind. But we saw that repeatedly in the early courts. And then the final mode that I would see natural law reasoning kind of playing in our form of interpretation, something that I also mentioned earlier, is when a positive law outcome, be it a statute or a judicial decree, is just so manifestly contrary to the principles of natural law. And of course, I mentioned earlier Dred Scott and Lincoln's essentially just treating Dred Scott, like Bill Clinton would treat a hooker in Little Rock, Arkansas. So I mean, like he essentially just took that, and he didn't abide by it, anything other than Dred Scott, the party to the lawsuit. And that's a natural law appeal right there. Is what Abraham Lincoln did in that in his decision to treat Dred Scott very frivolously. And what Adrian says on Twitter many times, I think he's right about this, frankly, is our Constitution is a normatively good Constitution. Again, I've said that repeatedly. That's always been my stance. But positivism can never be the ultimate appeal. There has to be something higher. If you go back to Nuremberg, what did they say in Nuremberg? They said, I was just following orders. So positivism can never be a final appeal as a true definition of law. And when the positive law and the natural law are in such irreconcilable tension with one another, the natural law simply has to prevail over the former. The question then at that point, it's kind of an intrinsic matter, is whether law as an interpretive discipline itself commands natural law over positive law, or whether we are just choosing to ignore the law. And that's kind of a more philosophical debate. But at that point, regardless of how we philosophically view it, the natural law has to prevail.
Josh, I have to jump in. Sorry, Judge. I think I disagree with everything I just heard from you. It's unusual. I don't think Dred Scott is quite what you make it out to be. I think the result in Dred Scott was a result of natural law reasoning, very poor natural law reasoning. It was a substantive due process case where the first, where Chief Justice Taney said that slaves were property, African Americans were a degraded race, and then Congress couldn't ban slavery in the territories, even though their Article 4 says Congress has the power to make all needful rules and regulations for the territories, and had been exercised since the beginning of the Republic. It was a natural law opinion couched in originalism that got the original meaning totally wrong. And that's what Lincoln said. Lincoln said, look, it's totally wrong on the merits. It's what Benjamin Curtis said in dissent. It's totally wrong on the merits. Can a free Black be made a citizen of the United States? As Curtis said, there were free blacks who were citizens of the states in 5 states before the Constitution was adopted. The Constitution took them as it found them. The naturalization power is the power to make new citizens, not to strip citizens, right? So the Dred Scott decision, I think, was a very willful, natural law-y opinion. And I think what Lincoln was saying is it was wrong on the merits. And as a matter of the judicial power, the original meaning, not natural law meaning, the original meaning of the judicial power in Article 3, the Dred Scott decision was binding just on Dred Scott and Dred Scott's master. And Lincoln encouraged Congress to reenact the Missouri Compromise precisely for that reason, because they shouldn't be bound by the Supreme Court's pronouncement as a political rule, at least he said until the issue is fully settled, right? But until then, it's binding on the parties. So I don't know. I think Lincoln was appealing to the Constitution and Taney was appealing to natural law. And with those fighting words, I'd love to hear what you have to say about that, but I know we're running out of time. And
yeah, I'm happy to respond, or 4 minutes left.
Josh, why don't you go ahead if you want to, and Frank, feel free to jump in. And then, but as soon as you're done, we'll ask one last question. That I think we've got a great one out of the chat room, and we can wrap it up.
Okay, yeah, I'll try to keep this 60 to 90 seconds, just for sake of time here. I guess at like the highest level possible, I just fail to see how an opinion that holds that Black human beings are not essentially human beings can possibly purported to be girded in the natural law and the principles that Jefferson wrote in the Declaration of Independence. And that was kind of Lincoln's overarching theme his entire political career, of course, is that the Constitution was only the frame of silver for the Declaration as the apple of gold. It's true, Ilan. President Lincoln did encourage positive law reforms, culminating, of course, with the 13th Amendment, which the movie Lincoln, was it Spielberg film, came out a few years ago. I mean, that's all about the ratification of the 13th Amendment. So there obviously were positive law reforms to Dred Scott, but he also willfully defied it. He issued passports to free blacks in the territories. Look, whether that is purely a positive conception of the Article 3 powers being limited to a case or controversy and litigants to sue, something that I have espoused for years, whether that's a higher natural law reasoning there, I guess I don't see those two themes as being in tension with one another whatsoever. I think that Lincoln, in choosing to ignore Dred Scott and speaking of it in the vituperative, scathing language that he did in his first inaugural address, talking about how the people would cease to be their own rulers, lest they kind of delegate all the power to that, quote, most eminent tribunal. It seemed to me that he was speaking in both purely positivist Article 3 case or controversy legal reasoning, but more higher than that, I do think he was appealing to natural law reasoning.
Well, let's ask one final question. I think there's been a bunch of these. We've touched on some of the things discussed in the chat room, but let me try to synthesize a couple of them and get some final thoughts from y'all. One of the things we've been talking about throughout this webinar is what do we do in these hard cases, right? That's the theories of interpretation where the text runs out or the precedent runs out. And as to use Josh's word, what slides in then and how does it slide in and what is the content of the interpretive methodology? Why aren't we talking more, one of our participants has asked us, about constitutional amendments, right? So Article 5 is in the original Constitution. It proposes a way to change the Constitution when the people decide that it's necessary to do so. Is the reason for this great debate about the so-called construction zone or the end of positive law, or however it is you want to frame it, is it because the thresholds for Article 5 are so high? Is it because it's been tried so rarely? And we've talked a lot about the Reconstruction amendments. I assume we would all believe that those are positive laws and things that have effectuated change in a way that people wanted it done, rather than through judicial decisions. Amalgam of thoughts and ideas, but I'm curious for your reactions.
I'll take a stab at this. The first thing that I'll say is, if the Constitution doesn't say anything about something, then it's left for democratic deliberation. That's how the framers expected we would evolve and progress over time, right? If they didn't want us to evolve and progress, if they didn't want change, they would have baked more things into the Constitution. The whole point is they didn't do that precisely because they believed in progress, they believed in scientific and moral progress, I think, and they expected us to sort of effectuate that and through the democratic process over time. And they gave us the amendment process for the most fundamental of the regime changes. And that's in fact how we've used it. to abolish slavery, to guarantee equality in states in the 14th Amendment, various suffrage, right? African-American suffrage, women's suffrage, 18-year-old suffrage, and so for the most fundamental of regime changes, that's exactly how we use the amendment process. And the rest it's actually very easy to get change done, right? You do it through the democratic process. It's true, some things are untouchable, right, without an amendment, like First Amendment and Second Amendment and things like that. But those are rights that I think were essential then and are essential now to free societies. And so I'm very much okay with using the amendment process, the high threshold for those most fundamental regime changes, and leaving change where it belongs, the democratic process.
So I've waffled back and forth on Article 5 conventions many times over my fairly young legal and commentary career. I mean, there really are competing emotions at play here. I mean, the Burkean skeptic in me is here, there, and everywhere afraid of, forces that we don't want kind of overtaking that proverbial convention. But overall, I do come down on the side that an Article 5 convention of the states at some point would probably be good as a matter of civic efficacy, if nothing else. That is ultimately, the polls over and over again, the Annenberg Polling Center at the University of Pennsylvania, something like 1/3 of Americans can name all three branches of the government. I wrote a column last month about how the coronavirus potentially could possibly result in a silver lining of a religious great awakening. But, we as a people also need kind of a constitutional and a legal reawakening. And that's not for the people on this webinar, obviously. But I think an amendment process or trying to get some amendment ratified purely for the sake of civic efficacy could be good. And now, just a quick note, and I was running out of time. Ilan obviously is onto something quite sincere here. My conception of the consent of the governed and lowercase r republicanism is not quite Adrian's. Again, Adrian happens to be a not thinly veiled monarchist. I am not a monarchist. I believe in the separation of powers. And I do share, just to make this point clear, I share Ilan's conception that the democratic process is for the overwhelming majority of time the best place for substantive argumentation of the common good to play out. My claim, however, is that a purely positivistic, morally detached approach to the law is not only not the founders' originalism, but it is also untenable for the exact same reason that asking a news reporter to be politically neutral is untenable, because it is a lie against us as human beings, fundamentally.
Well, we're going to have to leave it there, I think, because we're out of time. Next time, maybe we can have a debate about Frank Buckley's internet service provider. We're sorry that he wasn't able to join us for the conclusion, but our greatest thanks to the Houston and Austin lawyers chapters of the Federalist Society, April, for all of your leadership in setting this up, all of the folks at the FedSoc for their coordination as well. What a wonderful and lively discussion. And I'm sure that, as with all things at the Federalist Society, the debate will continue. So thank you very much to our panelists and all of our participants in today's webinar.
Thank you so much, Judge Oldham, for leading that excellent discussion. Thank you, of course, again to our panelists. Thank you for the folks at Thank you to the folks at FedSoc for setting this up today. And also, we have applied for Texas CLE credit for today's dialogue. So we have a record. If you attended by Zoom, if you attended by phone, please feel free to email FedSoc and let us know that you were in attendance today, and we will try to get everybody some credit for that. Thank you so much for joining us, and we hope you have a great rest of your day. Thank you.